My name is Kathleen Leahy. I, along with Vida Amani, am co-director of Feminist Legal Studies Queens. And here with me also is Kevin Banks, who is the director of the Center for Law in the Contemporary Workplace, and with him, Manoj Diaz. And we are here to welcome Anna Chapman, who has come to us through the ice and snow from Melbourne, Australia, at the University of Melbourne, to speak to us today about the continuing resonance of breadwinner norms in Australian labour law, which is, when you take a close look at the text of the paper and the abstract, takes the concept of norms very seriously and goes beyond just male roles, female roles, but goes also into the dimensions of same-sex identifications, lesbian, gay, trans, intersex persons also attempting to fit themselves into the breadwinner framework. Just a brief introduction. In Feminist Legal Studies Queens, we like to just tell people who are here how someone like Dr. Chapman, Professor Chapman, got to where she is, because this may help inspire your path forward as well. Dr. Chapman started out with bachelor degrees in both commerce and law with honors, so you do have to work hard, from the University of Melbourne. Then she went on to get an LLM degree at the University of Melbourne and a PhD from the University of Adelaide, and received a Dean's Commendation for Doctoral Thesis Excellence, still working hard. And she is now an associate professor in the University of Melbourne Law School, and is the director of the Center for Employment and Labor Relations Law there, and has also been a program director in an MLM, Employment and Labor Relations Law. Also a long history of publication and editing. I am impressed to see that she's been ranked in groups of scholars who have the largest numbers of publications. We rarely have anybody who gets ranked in like the top 20 in the most prolific publishers in law, because you do have to really work hard to do that. And she has practiced in this area of law and now is a specialist in employment law, gender, sexuality, and race, and looks at that in connection with ideas of substantive equality, not just with sort of, simple questions of equal access or, yes, we have some women here. So with that, I'd like you to join me in welcoming Dr. Anna Chapman, who will now speak to us.
Thank you. Thank you, Kathleen, for that very warm welcome. It's my great pleasure to be here today. I'd like to commence by thanking Kathleen and also Kevin for inviting me here today, and also for Natalie for facilitating all the arrangements, of which there's been many. So my paper today is really a work in progress, and you can see if there was a printed paper, and it is headed draft. I have presented this paper previously, but as it is a work in progress, I very much welcome people's thoughts, comments and suggestions. So please feel free to contribute towards the end. So the paper today looks at the main legal developments in Australia that are designed to assist mothers and others in the workplace with care responsibilities. So those care responsibilities might relate to babies, children, adults such as partners who are ill or with a disability, or perhaps elderly parents. The legal developments I'm looking at today relate to labour law, and I include in that discrimination rules or discrimination law. I'm not looking at related areas of government policy such as childcare or the taxation system. And the paper uses a breadwinner framework to reveal ways in which Australian efforts in labour law and discrimination law have displaced some markers of a breadwinner ideology, but at the same time replicate central aspects of that thinking. So to turn first to the Australian foundation of breadwinner foundations. So it's very much the case that Australian law and legal regulation of work relationships is built on a breadwinner foundation. Of course, that breadwinner framework or foundation is not unique in Australia and is found in many Western countries at the turn of the 20th century, and I'm sure in Canada too, although I haven't actually specifically looked at that, but you might be able to assist me in that towards the end of the presentation. In Australia, it's most closely associated, and I guess it's best illustrated really by this 1907 judgment called the Harvester Judgment. And that's really the foundation of the wage setting system, at least in Australia, and really beyond the wage setting system. In this case, known as the Harvester, the court was called upon to interpret legislation. So the legal question was whether a group of male workers received a fair and reasonable wage. And the consequences of that decision was that if the workers did receive a fair and reasonable wage, then their employer had certain protections from imported goods. But if they didn't receive a fair and reasonable wage, then their employer was not protected from overseas manufacturing coming into Australia. And so the judge in that case, Justice Higgins, determined that in order to satisfy the test of fair and reasonable, the worker's wage must be sufficient to financially support, in the words of the judge, the normal needs of an average employee regarded as a human being living in a civilised community. And to understand that, or to determine that, the court investigated the cost of living of a labourer's home of about 5 persons. It was never really worked out how many, but of about 5 persons, in relation to what His Honour described as normal wants under normal conditions. So the court took into account evidence regarding the cost of rent at the time, and evidence regarding the cost of goods and services, or particularly food, I think. There was evidence given by a butcher and a land agent about the cost of accommodation. And at the conclusion of the investigation, Justice Higgins established a specific rate as being the fair and reasonable wage for an unskilled labourer, and that was based on a 40-hour working week spread over 6 days. And that wage rate became known as the basic or the living wage. So it's clear that, of course, the judge, Justice Higgins, did need to build a model on who was going to be the average employee. And it's clear that Justice Higgins built his model of fair and reasonable wages on a number of foundational assumptions about the worker and his life outside work. And prime amongst them was, of course, that his so-called average employee was a male breadwinner husband who financially supported a wife and 2 or 3 children. Not sure how many children there, but perhaps it doesn't really matter. And then His Honour assumed, of course, that such male breadwinners were able to and did in fact work 48 hours a week over 6 days. So as Sandra Burns has written in a 2001 book, she pointed out that it's clear that there was an implicit assumption here that the worker did not have any substantial care or domestic tasks, or else he couldn't work 48 hours a week over 6 days. And so in the Harvester frameworks, those sorts of needs, care and domestic needs, were met by the worker's stay-at-home or the homemaker wife. And so that case was in 1907. The reality of women workers couldn't be ignored, and there was a case brought 5 years later in 1912 called the Fruit Pickers case. And it was the same judge, Justice Higgins, was needing to decide what should be the wage rate for women workers. And in this 1912 case, Justice Higgins determined that in the less likely event that women were working in the same jobs as men or alongside men, then women ought to receive the same basic wage as men. Otherwise, their employment would undermine male employment. But in the more likely scenario, at that time, women were working in occupations that were different to where men were working, which was far more likely, then women ought to receive 54% of the male basic wage. And the assumption there was that women workers were financially supporting themselves alone. And so those decisions on the female minimum wage and the male minimum wage, I'll just go with the female minimum wage. This decision on the female minimum wage clearly identifies the counterpart of the harvester breadwinner man, an unmarried childless woman worker. Justice Higgins' model of the average female employee, as he referred to it, assumed her to be unmarried because she was not being financially supported by a husband, and she was without children or others to support. Indeed, there's a number of cases at this time in about 1912 and a few years after that, where some judges actually explicitly conflated female workers to single women. So they actually used the language of single women instead of talking about women workers. So this brings me to my paper. The paper I'm looking at today is really focusing on the normative assumptions of the breadwinner model regarding gender and sexuality. I'm not looking at other sorts of normative assumptions that Justice Higgins made, and he clearly did as well, make assumptions about people were able to work 48 hours a week over 6 days, so he made assumptions that I guess people don't have disabilities that would shape their ability to work 48 hours a week over 6 weeks. He didn't also look at race and ethnicity, and I think that would be very relevant to look at in his assumption about who's working and who they're supporting. He assumed that they were just supporting a nuclear family and not a sort of broader obligations to a kinship group, for example, in Indigenous communities. So I'm not looking at those, I'm just looking at gender and sexuality. And my purpose here is to explore the continuing resonance of those gender norms from Justice Higgins's time, in the sense of the sort of taken for granted, largely invisible assumptions that gender exists in a binary framework in which men have a natural and distinct role in life, as do women have a distinctive role, and that the gender roles of women and men are complementary to each other. That's what I'm seeking to look at. And the paper uses, or at least mentions, the concept of heteronormativity, which was developed in the 1990s, but with much earlier origins, of course. And that concept of heteronormativity draws attention to the mechanisms through which heterosexuality is reproduced in the normative sense, or as a normative sexuality. As Leslie Moran has written, heterosexuality is one of those, is in some respects like the air we breathe, a diffuse or pervasive presence, a sense of rightness, but at the same time out of mind, unnoticed, unrecognisable, often unconscious and imminent to the practice of institutions. So this paper attempts to uncover the unnoticed and the often unconscious norms of sexuality and gender that are embedded in the mechanisms and legal entitlements of Australian labour law. So in terms of turning now to displacing the breadwinner paradigm, has it been displaced? Clearly Justice Higgins' modelling in 1907 of the average employee, and then in 1912 the average female employee, reveals the naturalisation of distinct gender roles and the normativity of heterosexuality as the expression of sexuality. These gender roles mapped easily onto the separation of work and care, and reflected the broader social compact at that time of Australian society regarding the proper roles of men and women, marriage and sexuality. And then, of course, over the course of the 20th century, that social contract changed. In particular, the 1960s and the 1970s saw extensive social and political change in Australia, including in relation to feminist claims for equality and the burgeoning gay liberation movement. These social movements impacted broadly across society as well as the legal system. These broader social and political developments impacted upon the Australian legal regulation of work relations over the second half of the 20th century and into the 21st, and a platform of legal rights was developed across a range of different entitlements that I'll discuss in a few moments, including equal pay, leave entitlements, discrimination protections and a right to request scheme. The paper now turns to more closely reveal the dynamics through which the Australian breadwinner model is both displaced to some degree but also replicated in other degrees. So the paper does this by adopting three standpoints or themes or dynamics, I'm not really sure which, that offer the most potential, I think, to disrupt the gender and sexuality normativity of the breadwinner framework. That is mothers as workers, father workers, or perhaps just shortened to fathers as carers, and then thirdly, lesbian, gay, bisexual, transgender workers and their families. So I think I drew up these three standpoints because I think these are really points at which we can see to what extent the breadwinner has been displaced and to what extent law is continuing with these norms from 1907. But there might be others, in which case I'd be really happy to hear your thoughts on that. But I think these work, so I'll be interested to know what you think. So let's start then with mothers as workers. So There have, of course, been a lot of legal developments. Initially, in fact, there were some rules that explicitly discriminated against women workers. There were some rules in the Commonwealth public sector. There was legislation that deemed that when women married, they were taken to have retired, and that was the end of the story. So in the late 1960s, those laws were repealed, and they're sort of some of the first steps, I guess, at recognising that women should be able to remain in employment after they're married. And then in the early 1970s, the Australian system of wage setting that I briefly described, where women received a proportion of the male wage, that was challenged, and in the early 1970s, equal pay was won or was substantiated. And so now the concept is that people are supposed to be paid minimum wages according to, and the minimum wage for each type of job is supposed to be based on equal pay for work of equal value. Formally, at least, equal pay for women has been won in the 1970s, although of course that doesn't mean that equal pay in fact has been achieved, and there are many ongoing claims in that regard. Another development that happened in the early 1970s is there was a series of test cases, and then it became formalised through legislation that maternity leave was developed. So this was specifically for women in the early 1970s. And the standard that was set in the early 1970s is actually still the standard we have in Australia today. And it is that in the private sector, the entitlement is for mothers to have 1 year of unpaid absence from work. So important to recognise it's unpaid absence from work, and then a right to return to their former position or an equivalent position if that former position no longer exists, perhaps through a restructure of the work arrangements. From 2005, that right for 12 months unpaid leave was extended to a right to request a further 12 months, so potentially up to 24 months, all unpaid. That request to extend for up to another 12 months can only be rejected by an employer on reasonable business grounds. So that form of unpaid parental leave, or maternity leave, perhaps I'll call it here because we're talking about work mothers, that continues today. And so of course that leave, maternity leave, unpaid maternity leave, with its right to return to work, was very important because it provided recognition that being the mother of a baby and being a worker are not mutually exclusive. In other words, it became legally possible for a woman to be both a worker of the labour market, albeit a temporarily absent and unpaid one, and a mother of a baby. Because prior to those developments in maternity leave, women who became pregnant and gave birth had no legal entitlement to be absent from work beyond what they would have had by way of sick leave or perhaps annual leave, which before the 1970s would have been very limited. Most likely, I mean nobody really knows, but most likely pregnant women either resigned their position or attempted to reach some kind of mutual agreement with their employer, who may or may not have been receptive to their absence. Because of course any extended absence from a workplace without an employer's agreement would likely constitute an abandonment or frustration of their contract of employment. And then of course until the enactment of sex discrimination legislation in the 1970s, women could lawfully be dismissed on a range of grounds, including because they were pregnant or were a parent or simply because of their gender. Then from the 1970s, discrimination legislation was enacted, and this legislation provides a right to seek redress in relation to discrimination on the ground of sex, as well as related attributes such as pregnancy, responsibility to care for others and breastfeeding. In some states in Australia, the legislation moves beyond ideas of direct and indirect discrimination to recognise another type of discrimination, that being a failure to reasonably accommodate. So in some parts of Australia, employers have a legal obligation to reasonably accommodate on the ground of care responsibilities. Also on the ground of disability, but perhaps that's less relevant for today's presentation. And so there are also further developments that I'll mention. In 2009, we had a new statute was enacted, the Fair Work Act, and it included these provisions that are known as adverse action. And these sit alongside the discrimination law framework. So these provisions provide redress to workers who have been treated adversely, including in a discriminatory manner, on the basis of a number of attributes such as sex, family or care responsibilities, pregnancy, again, or because they've exercised a workplace right to, for example, take maternity leave. So this is another avenue of redress for workers who feel that they've been treated adversely because of their gender or their family or care responsibilities or pregnancy. The Fair Work Act also contains a right to request mechanism, which is a mechanism that we've borrowed, Australia borrowed from the UK. It enables workers to request a change in work arrangements. So that might be to request a change in working hours or place of work or day of work or shift of work in order to enable them to accommodate their care responsibilities, in addition to a number of other circumstances in Australia. And technically, employers are only entitled to refuse that sort of request on reasonable business grounds. And so the idea of reasonable business grounds is the employer might say this is not going to be something we can do, it has too harmful an impact on customers or other workers, for example. So on the face of those discrimination laws and the right to request in the Fair Work Act and adverse action, there is much support on the face of these laws anyway for working mothers. They not only provide redress in relation to discrimination and more broadly adverse treatment, some statutes proactively require, as I mentioned, the reasonable accommodation of working mothers in the form of a change of hours of work or change of location of work, etc. The next major development, I guess, legal entitlements for the purpose of providing forms of care or support outside the circumstances of birth or adoption. These were first recognised through a series of test cases in the mid-1990s. These provisions became known as personal carers leave, and that's how I'll refer to them. These provisions permit a worker to take paid time off work because they are sick themselves or to deal with an unexpected illness or injury to a member of their family or their household. The entitlement is for 10 days of paid leave per year, which amount accumulates over the course of the year and from year to year. Because prior to these test cases, it was apparently a widespread practice for mothers to use their own sick leave in order to care for a child who was unwell and couldn't go to school that day. Strictly speaking, though, that practice breached the legal rules on sick leave, and although it is said that many employers ignore the contravention, the unlawfulness of the behaviour, I think, underscores the difficult situation mothers found themselves in prior to this personal carers leave in the mid-1990s. It also shows the lack of legal support for mothers as workers. And then most recently, in 2010, our previous Labor government enacted a new statute establishing a parental leave payment scheme. And this scheme provides a government-funded payment for people who are on unpaid parental leave. So the money for the unpaid parental leave, the money comes from this 2010 scheme, I should say. So the legal entitlement is to unpaid parental leave or maternity leave, but there is this sort of supplementary allowance from the government. So this is a government-funded payment for employees and other workers who are the primary carer of a baby, and it provides up to 18 weeks of payment at the rate of the weekly minimum wage. And so that's a vast improvement on the situation that many workers faced previously, because, as I've mentioned, the minimum maternity leave is an unpaid provision. It is true that some collective agreements have contained and continue to provide rights to paid leave related to maternity, but the spread of those schemes has been very slow and uneven. Did you want to, or should you? Yep. Absolutely. So I will talk about men when we get to fathers carers, so I'm still on the mothers. But yes, I will get there, and they can, but they don't tend to, in fact. It is at the minimum wage. Okay, but back on to looking at what sort of provisions are in collective agreements. It's known that at 2009, so on the eve of this 2010 scheme commencement, it's known that less than half of working mothers had access to paid maternity leave, and large groups of women, especially those working as casuals and in small and medium sized private sector businesses were far less likely to have coverage by a paid scheme. At 2009, the most common provision of paid maternity leave where it existed was for 14 weeks of paid leave. So that's below the 18 weeks. And so I think you can see from this brief profile of legal developments that there is considerable activity. There has been considerable activity in the second half of the 20th century and into the 21st century in terms of equal pay, leave discrimination, a right to request, and this parental leave payment scheme. And so clearly being a mother and a worker is now legally compatible, and the legal framework does contain a number of rules and initiatives designed to assist mothers to manage their work commitments with their care responsibilities. Nonetheless, a national review conducted by the Australian Human Rights Commission over 2013-2014 found that discrimination related to pregnancy, parental leave and return to work after maternity leave was pervasive, and that's a quote, pervasive in Australian workplaces. Indeed, the review records that 1 in 2 mothers reported being treated unfairly or disadvantaged in their workplace at some point. And so the different legal mechanisms I've outlined, they are undermined. They have many substantive limitations. There are many procedural shortcomings. And I'll mention some of those. And I think in these sort of shortcomings of these provisions for mothers in the workforce, you see the ambivalence of labour law, I think, and I think it's in these shortcomings you also see the sort of breadwinner framework reflected coming through. So, to start with, eligibility rules. Some of these legal entitlements that I've just mentioned do reflect the idea that a worker is a full-time and continuous employee. And so reflect that gendered breadwinner paradigm where the breadwinner worker was full-time and continuous employee. And of course that really is at odds with women's work in Australia. In Australia, precarious work, that is casual, short-term work, has become feminised. This is the work into which mothers are going increasingly. And in fact, it's the type of work that's been promoted as being particularly suitable for mothers. The problem of that is, of course, is that then it means mothers are less likely to have access to the sorts of rights I've just outlined. And so I should say to you, let me be a bit more specific about that, that right to unpaid maternity leave of 12 months and then a potential extension for up to another 12 months, as well as the right to request mechanism, they can actually only be accessed by employees at common law and not contractors. And they can only also be accessed by employees who have completed at least 12 months of continuous service with their employer before they apply for unpaid maternity leave or before they seek to change their work arrangements. Both those arrangements additionally exclude casual employees who have 12 months, more than 12 months service, unless those casuals were engaged on a regular and systematic basis and also had an expectation of ongoing regular and systematic work. In relation to personal carers leave that I mentioned, all casuals are disqualified from eligibility. In Australia, casuals make up about 9% of the workforce, and in fact they may have been employed by that employer for 4 or 5 or longer years, but they're completely excluded from any right to personal or carers leave. And so I think that really undermines these provisions. Some more shortcomings I'll mention is the second point there on the overhead. The right to request mechanism has some major limitations which my students just find it hard to believe until I take them to the sections in the Act. So I won't do that because I didn't bring my Act. But if you can just trust me, it is all there. An employer's refusal of a person's request to change their work arrangements in order to accommodate their care responsibility, the employer's refusal cannot be challenged, even if it's clearly unreasonable and if it's clearly no basis in reasonable business grounds. There is no cause of action where an employer's refusal is clearly unreasonable. In effect, of course, the scheme provides a right to ask only and not a right to receive accommodation. And I think that's really important. So there is no case law because there is no legal right to challenge. And of course the government would say this is the first step to say to employers, you really should consider these requests and you should grant them if you can. But if the employer doesn't take that attitude, there is no legal enforcement attached. But I must say that the empirical evidence does indicate that employers do frequently grant requests. They may not grant the request in full, but they grant something like the request in something like 90% of cases. So there is a high level of employers granting the requests, I think indicating that this is about keeping employees. They're actually keen. It's the forces of the market are actually doing this. The employers are not legally required to do it, but the forces of the market is encouraging employers to keep good employees. But there is some research, case study research, that does reveal a lack of fit between the requested new arrangement and existing expectations. So, for example, there is some evidence that mothers who return from maternity leave may come back to work with reduced hours, but with the same volume of tasks and no reduction in expectations from their line managers. So they may have negotiated to come back to 4 days a week rather than 5 days a week, but they've still got the same workflow coming through their desk. And so there's an indication there that this is a problem. It shows, I think, a lack of fit between the right to request mechanism and other sorts of management arrangements and contracts of employment, I guess specifically. Which I think all, further further undermines the efficacy of the right to request mechanism to displace the breadwinner paradigm. Just to mention quickly discrimination legislation, it has been interpreted in narrow ways by judges, and I won't go into that. There aren't a great number of cases that get to a public hearing. In fact, the discrimination obligation on some employers in some parts of Australia to reasonably accommodate, there's been no cases testing those at all, so it's difficult to know what effect they have. It's very much relies on an individual enforcement by an individual aggrieved person. There is no public enforcement agency in relation to discrimination law, and so of course that's very fraught, bringing a claim against a well-resourced employer. Similar comments can be made about the adverse action provisions in the Fair Work Act. They are being interpreted by judges in a narrow manner. There's been very few successful cases on the grounds of pregnancy, care responsibilities, etc. Another point I'll just make, and then I might jump to the last point there. The personal carers leave, the formula for personal carers leave, at least the sick leave aspect of it, goes back to the 1940s. And so in Australia you're entitled to this personal carers leave for your own illness, but it's really, the formula is the employee is not fit for work because of a personal illness. And there's been quite a lot of concern that that's really a narrow formula. So if you think about it, does that mean that if you're a woman and you want to go to a reproductive health appointment or in vitro fertilisation, are you entitled to personal carers leave? Well, there's a big question mark. You don't really have a personal illness, do you? So there is an issue there about whether that formula up on the overhead is just too narrow to really capture the full range of legitimate reasons why people might want to access one of their paid days off, up to 10 a year. There's also big issues about things such as people in terms of disability, people who might need to go and have kidney dialysis treatment. Is that they're not fit because of a personal illness? Well, they will become ill if they don't have their regular treatment, but they're probably not ill at this point. So anyway, I'll leave that with you, hey? And I suppose I think we should also mention there are forces working in the opposite direction of mothers as workers. There are lengthening working hours in Australia, as in many Western countries. Also, there's been this increase in precarious work, feminisation of precarious work. So I think where we're up to then is saying that there has been quite a lot of activity in Australia in the second part of the 20th century to enable mothers to be workers as well in the workforce. However, they're really strongly undermined by a whole range of substantive limitations. Also, the way judges have interpreted various provisions is important, and then growing sort of broader trends in the labour market, pushing in the opposite direction. And so I think in all those ways they really undermine their ability to displace the breadwinner framework. So now let's turn to fathers as carers, so father workers really. So this is kind of the second standpoint I think is useful to look at. And this is where I'll say to you that from 1990, all those provisions I've mentioned have been drafted in gender-neutral manner. So all the provisions I've mentioned are now available to men. And so that started in 1990. So the unpaid maternity leave is now called unpaid parental leave. Can be accessed by either a woman or a man, so long as they're the primary carer. And I'll get to the primary carer part a bit later on. And so, of course, there is broadly equivalent legal support, or at least at the formal level, for men and fathers to engage in substantial care responsibility. As it is for fathers, as it is for mothers. So provided a father fulfills the eligibility rules, which he's more likely to do for unpaid parental leave, he's legally entitled to take an extended period of unpaid leave, potentially up to 2 years to care for a baby. When he returns to work, potentially he's entitled to request a return to part-time work, change from full-time to part-time, or change his days of work or his starting times, finishing times, etc. Whatever is reasonable and would assist him to manage his care responsibilities. There's also personal carers leave, if he needed to take a day off work in order to care for a child or someone else that he's responsible for. And of course, fathers are protected from discrimination and adverse action, as are mothers, theoretically. Okay, but I think there are many factors that point to the law in action being weaker for father carers than might appear on the face of the rules, as indeed there is for mothers. Around 1/4 of fathers report experiencing discrimination when requesting or taking parental leave or when they return to work. Now that's less than women, and I think that's because men access these things less, I imagine. There are very few requests, and I don't have exact numbers, but I think the quote is few requests. Very few requests under the right to request mechanism are made by men. In one study, there are few requests that are made by men to reduce their working hours. When there are requests made by men, they all have been to reduce their working hours from 5 days a week to 4 days a week in order to have 1 day at home with young children. So I would say that represents a modest subsidiary contribution to care responsibilities. So they're not taking on the role of being the main carer. From 2010, fathers like mothers have access to the parental leave payment scheme. So you remember that that's at the minimum wage. Indeed, in 2012, there's been an extra payment added, and it is titled Dad and Partner Pay, and the Act is the Dad and Partner Pay Act. So you don't see that word dad used in legislation very often, but it is used in this Act. Presumably, I think to try to make it more friendly. I don't know whether it makes a difference, but it is called the Dad and Partner Payment. It's an extra 2 weeks that can be taken by a dad or other partner of the birth mother. However, it seems that not many men are doing this. It is at the minimum wage, and so that's a big factor in a family's income, I guess. It's not high, the minimum wage, by Australian standards. It's thought that only around 1/3 of eligible fathers actually claim this dad and partner pay. Provisions in collective agreements for men are very weak. 1 week is the most common duration of paid leave for fathers, and that was at 2009. In the result, the evidence suggests that the average length of leave taken by fathers in the first 2 months after birth is only around 11 days. And so I'd say, generally speaking, the legal framework provides broadly equivalent support for father workers to be carers as it does for mothers to be workers of the labour market. Indeed, in some respects, such as this 2-week dad and partner pay, there's additional support for fathers, reflecting Parliament's, stated concern anyway, to try to encourage men to be more engaged carers in the early years. But there are also many strong factors that push against fathers being carers as well, and work to keep men in a gender role as an unencumbered worker, including fewer provisions for paid parental leave in collective agreements, and I think strong cultural values around the proper role of fathers as breadwinners. Of course, long working hours doesn't assist, and that reduces the time available for men to be carers. So that's fathers as carers. Now, could we look then at LGBT workers and their families? Of course, the breadwinner model of Harvester back in 1907, no surprises there, was constructed on the basis of the heterosexual nuclear family formed through a marriage relationship. Over the course of the second half of the 20th century and into the 21st, the claims of equality made by lesbian and gay groups, and then more recently the LGBT community, brought mounting pressure to bear on many different areas of government policy as well as law, including in relation to the legal regulation of work relations. So in response, labour law reform has taken two main forms. Really, the groundwork for the second was laid by the first. So there's been two real waves of law reform. The first wave focused on the worker as an individual and provided an ability to seek legal redress in relation to discrimination experienced by that person because of their sexuality or the related concepts of sexual preference or sexual orientation. And this happened at very vastly different times across Australia. For instance, New South Wales was one of the earliest discrimination protections, and a ground of homosexuality, as it was worded, was introduced in 1977. The most recent is actually at the federal level, where grounds of sexual orientation and gender identity were added only in 2013. Even more recent grounds across discrimination law is the ground of gender identity or being transgender. That's a very recent addition to most statutes. So by prohibiting discriminatory decision making by employers related to a worker's sexuality or their gender identity, the legal entitlements confirm that heterosexuality and a binary immutable gender are not mandatory norms of the worker. In this way, these developments displace to some degree the heteronormativity of the breadwinner paradigm. At least in terms of formal legal rules, it's no longer required that workers stay in the closet regarding their identity as lesbian, gay, or risk the consequences of discrimination in relation to which there was no obvious remedy. But the legal message regarding being transgender or gender diverse is far more muted, because our main labour law statute, the Fair Work Act, doesn't explicitly prohibit discrimination on that ground. Discrimination law is beset with many substantive and procedural limitations, as are the adverse action protections of the Fair Work Act. And these more general constraints are experienced by LGBT workers as by all workers. But there are some additional barriers for LGBT workers. The first one there I've noted on the slide are the exceptions for religious organisations and employers acting on the basis of their religious beliefs. This, of course, the Parliament would say is a balancing of different interests, human rights not to be discriminated against the rights of religion. And so there are quite broad exemptions in our discrimination statutes and the Fair Work Act for religious organisations, basically, who can make the argument that they're acting on the basis of their religious beliefs. And on that basis, they're not hiring somebody because of their sexual orientation. Now, I would argue these religious organisations' exemptions do have an impact on LGBT workers, and they discourage claimants as well as actually reducing the level of protection offered. Now, there's very few cases on the meaning of any of that, I think because claimants are discouraged from bringing claims. In addition, of course, in order to bring a claim on a ground of sexual orientation or sexuality, people have to identify that as their sexuality. So needing to out yourself is likely to be a significant matter for many LGBT workers. There's been some research conducted by the Australian Human Rights Commission in 2014, and it found that 62% of LGBT people surveyed reported that they felt they were unable to disclose their sexuality or their gender identity at their workplace, despite wanting to do that. So I think this finding indicates that a majority of LGBT workers in Australia see significant costs in being open about their sexuality or their gender identity. Given that, I think it's not surprising that few claims are brought under these grounds. So that's the first wave of law reform that focused on the individual worker, and then the second wave really focuses on the LGBT workers' care and family networks. So I think in a way this provides a more direct challenge to the harvester heteronormative family. So during the 20th century, many of the legal entitlements regarding care responsibilities were quite explicitly and consciously framed to require a heterosexual relationship. So for example, a worker only qualified initially for the statutory entitlement of unpaid parental leave where the woman who gave birth was their spouse or their de facto spouse. And then de facto spouse was defined to mean a person of the opposite sex to the employee who lives with the employee in a marriage-like relationship, although not legally married to the employee. So you could only get it if you're a man in a de facto relationship with a woman who gave birth, basically. Australia never has and still doesn't recognise same-sex marriage as a lawful marriage in Australian law, so we can sort of discount the idea of marriage there. Of course, these definitions, they had the idea of the opposite sex, and that indicates a binary reading of gender. You could be male or female, one or the other, but you can't be transgender or gender diverse under these sorts of rules. So more recent amendments do provide a recognition of same-sex relationships, or at least couple relationships. Generally that's been achieved through redrafting the concept of de facto spouse or partner. Again, different parts of Australia have done this at different times, depending on different government priorities. But the Commonwealth only recognised same-sex couples in discrimination law in 2008 and in the Fair Work Act, our labour law statute, in 2009. So this is all really quite recent. And the statutory schemes provide recognition to LGBT workers and their families who can prove the existence of a relationship within the meaning of the legislative definition. Of course, that stands in contrast to married workers who need really merely assert that they're married to receive the entitlement, whereas LGBT workers have actually got to establish it. And there's two themes that remain present in current legal definitions of recognised relationships that I think do resonate very strongly with those 1907 Breadwinner norms. And these exclude family relationships that don't comply with these norms. And the two themes that I think are still present in Australian law is this idea of a two adult marriage-like couple, and then the idea of a primary caregiver model. So let me look at each of those in turn. So the idea of a two adult marriage-like couple. Now perhaps I have to preface this by saying some legal entitlements are drawn much more broadly than this. So some legal entitlements just say if you have care responsibilities, you must not be discriminated against. And they don't seek to define care responsibilities. They just leave it very open. So of course I think that's a benefit, then that's less likely to exclude people. However, some of them are very old-fashioned still and do try to go into the difficult territory of defining what is a family responsibility and what's not a family, what is a family. And so our Federal Sex Discrimination Act, which is an important statute, it's at the federal level, so it covers the whole of Australia basically, does attempt to define family relationships. And so it does this, I've put it up there on the overhead, it does this because it prohibits discrimination in the work context on the ground of family responsibility. So somebody might feel they've missed out on a promotion, they've been dismissed because of their family responsibilities. Family responsibilities is defined in a way which includes a number of relationships, but also responsibilities to care for a partner in a de facto relationship. And so that takes us to the concept of de facto relationship. And then that itself is defined as a couple living together on a genuine domestic basis. And then from there, there's a look at a number of indicia to decide whether this is in fact a couple living together on a genuine domestic basis. So in determining that, the judge, the tribunal member, I guess the parties, the lawyers involved, are going to look at these factors A to H. And so you can see there about the longevity of the relationship, whether people live together, whether there's a sexual relationship between them, financial independence or interdependence. It's actually about financial dependence, isn't it? Not independence. It's about financial dependence there at D. interdependence, the ownership of property, do they own the house they're living in, etc., a car, the degree of mutual commitment to a shared life, the care and support of children, the reputation and public aspects of the relationship. And the legislation makes it very clear that it's irrelevant whether the two people are of different sexes or the same sex. So I suppose what can we say about that? The concept of couple is clearly there in the definition. That references two adults. Now, I've never seen any case law on that, but I'm sure it means two adults if you looked in a dictionary. So, of course, that two-adult model might not sit well with many care arrangements, including those of LGBT workers, but not solely of LGBT workers. So it fails to account, doesn't it, for diverse care relationships that exist outside two adult couples, such as might exist in polyamorous relationships, and also care arrangements between close friends and extended community or kinship networks. So it does only recognise a couple, which I think means two adults, although that's never been tested. And then if you look at the inclusive list of factors to have regard to, it actually historically has its origins in early divorce case decisions. And these were, when I say early, I mean from the 1970s, which is when we recognised divorce in Australia. So in these cases, judges needed to decide whether the husband and wife were in fact separated, although they were living under the same roof. So it was in those cases where judges had to try to grapple with, well, are they really a married couple or not? Still. And so that's where all those indicia come from. So, I mean, I think those origins reflect a referencing to heterosexual marriage. And it's an ideal of marriage, isn't it? And in that way, I think they clearly replicate the Breadwinner framework. They focus on domesticity, shared finances, raising children, and the public aspects of the relationship. I think those factors don't align well with many LGBT relationships. Yeah. Well, and so what I will say here, that these have never been interpreted in the work relations context. There is absolutely no case law on this. So I don't know now, but having said that, similar sorts of ideas are used in family law. And I believe there's quite a bit more flexibility in that sphere. So I must say I haven't really looked deeply into those family law cases, just because really it's a non-event in labour law. It's never been looked at. Yeah, but not according to the statute. So the statute doesn't weight these different things. That's just left to the judge. And I think you'll find different judges drawing different things in family law. But look, I think these don't align very well with many LGBT relationships where there is much diversity. Now, the evidence in Australia exists in relation to Australian LGBT relationships. There's a lot of diversity in terms of housing and financial arrangements, as well as the raising of children. I mean, the concept of the public aspects of the relationship, I think it would be particularly problematic for LGBT workers who are closeted about their relationships. So that's that, the two adult marriage-like couple. The other thing that comes out of the Australian legal regulation is the idea that it's still based on the idea that there will be one primary caregiver. So not two adults equally sharing, or more than two adults equally sharing. It is the idea that there'll be a primary carer and a primary worker. And so that, I think, really resonates, I should say, back with the Breadwinner framework. So the legal initiatives relating to the care of babies and infants, really, this is where you see this. They continue to reveal a primary caregiver model, replicating the Breadwinner framework of one worker plus one carer. So unpaid parental leave is available to the woman who gave birth or her spouse or de facto partner, as defined, but only one member of the couple are permitted to be on unpaid parental leave at the one time, other than 8 weeks. So at 8 weeks, two adults, the two adults in the couple, can be on leave at the same time, but apart from that 8 weeks, only one person is entitled to be on leave. So to me, that reflects a vision of care by one carer only, other than the 8 weeks of potential concurrent leave. And I must say, I don't think there's any research on the actual length. We know that the actual length that men take is on average about 11 days, I think I said. So not the 8 weeks. Under the parental leave payment scheme, only one person can be recognised as the child's primary carer and in receipt of the parental leave payment at the same time. The concept of primary care is defined to mean that the child is in the person's care in that period, and the person meets the child's physical needs more than anyone else in that period. So to me, that envisages that the person is the sole, or at least the main carer. Now that's softened somewhat in 2012 by that dad and partner payment, but apart from that, it still requires that model. And I'd argue that this primary caregiver model might be a poor fit for many families and care relationships, and particularly it seems to be a poor fit for lesbian relationships, where there is now quite a deal of empirical evidence that suggests that the care of babies and infants and household work is shared more evenly between a couple. And then I finished there with a quote from one worker in a lesbian relationship who gave evidence in 2004 to the Australian Human Rights Commission into supporting working parents, that neither my partner nor I like this system we live in, which requires there to be a primary parent. We are both primary, we are equally important parents, we both need to spend quality time with our daughter, we both have interesting and rewarding careers, we both need to make money. So then by conclusion I'll say, well, what I've attempted to do here is examine the continuing resonance of the breadwinner paradigm in current Australian labour law, including discrimination law. And I focused on gender and sexuality to reveal the ways in which the current legal landscape both in some ways moves beyond the breadwinner, but also in other ways replicates the breadwinner framework. And in the result, I think my conclusion in the paper is there remains a highly gendered and heterosex ideology of work and care that is embedded in the legal regulation. So thank you.
Thank you very much. What we will do now is we have probably 15 minutes for questions and discussion arising out of this fantastic presentation. I really appreciate it because there are so many parallels in the Canadian context, but some big structural differences, including the right to get married or recognized as a spouse-like cohabitant. Anyway, questions from anybody? I'll let you moderate this.
Sure, thank you, Kathleen. Oh, well, I've flummoxed you all. Hello. Yes.
You mentioned that there's a lack of case law in a few areas here, and I was wondering if that's because some of these reforms are more recent, or are there barriers to bringing?
I think that's a really good point. I imagine it's both. Some of these provisions are relatively recent, although it's been a few years now since the 2009 Fair Work Act. I think I think it is relatively recent, but nonetheless, I think the barriers are a lot of these mechanisms require the aggrieved individual worker to pursue them, which I think is very difficult and problematic. Also, of course, most of these legal rights, have a first step of conciliation, and so there would be cases there, although again, not many really. And so our process of conciliation is a confidential process. It's not publicly reported, although the agencies that carry out conciliation often do present little case studies in their annual reports to try to give people a sense of what's going on in conciliation. It is interesting, under the Fair Work Act, which is our main labour law statute, there is an relatively well-resourced enforcement body. And so there are some more cases coming through that avenue. But discrimination law doesn't have a public enforcement body. But still, we're not seeing the cases come through. Yeah.
I have a question about private practice in a law firm, which will be kind of relevant to many of us soon. So in Canada, it's getting a lot easier especially for women to take mat leave when they're still an associate because they're still an employee. But I know there's still two issues that come up that I don't know if the law has room to fix, but I'll just see what your opinion is. And the first one is that because there's time taken away, we'll always be a little bit behind, and we take a lot longer to make partner than men because we can't reach the billable that we need. And then I wrote down the second issue. Sorry, I get Oh yeah, also when you're on mat leave, a lot of times other lawyers have to take over your files and take over your clients, and doesn't mean that that's a malicious thing or a bad thing, but it's just a fact of, it's a reality, and in some ways women feel like they have to almost start over their practice when they return from mat leave. So I'm just wondering if you have any thoughts on that in the Australian perspective, or if there's room in the law, or if that's just collateral damage for us.
Oh, well, let's not leave it on the floor. It's collateral
Yeah.
damage. Well, look, I think in the Australian legal profession, things are pretty tough, actually. We have a number of reports over many years, and I'm not sure that things have improved all that much for women. Our stats on women partners are probably not, I mean, they're not great.
Yeah.
Look, I do think there are problems, but in a way what you're saying is that women are being penalised for taking maternity leave. And of course, that is discrimination in my mind. In Australia, there's been very few cases brought by women lawyers, I guess for obvious reasons, not wanting to be public about their complaint. But in terms of things like taking time out, our rules about indirect discrimination provide if there's a requirement, such as a need to bill 60 hours a week is probably what it is in Australia. Oh, I'm exaggerating actually. But to have certain high billable hours, unless that's reasonable, that's going to impact on people with care responsibilities. So I think in Australia we probably have the legal framework if you can negotiate your way through it, but I think there's a reluctance to challenge it in Australia. Yeah, there's been very few cases brought by women lawyers, but it does seem to me that the legal profession has been very slow in changing.
Yeah.
I'm not sure what the situation is in Canada, but certainly in Australia, in terms of professions such as accountants and financial services, there are many, many more women there in senior positions than in the legal profession. Is that similar in Canada, do you think? Or? Yeah, I'm not sure why law's so hopeless, but yeah, I think it's true to say in Australia law is really dragging its feet much more than the other professions.
Yeah, I think that bar associations are getting a lot better to be supportive of maternity leave, and obviously firms will pay for that leave. But I think, yeah, there's just these, you can never make up that time you lose, right? And that's kind of a concern for
Yep.
people wanting to take parental leave, especially if they have like an ongoing file, maybe in litigation that could last years or something.
Yeah. It's a difficulty, I think, and I think law firms are very slow in responding, and I do look at them and wonder why law firms don't respond, because they're losing so many women lawyers, which they say they're keen not to do. The HR people in law firms will say they're very keen not to do. They have lovely glossy brochures. They like to come in, they're probably the same here. They come and speak to students. They say, we're a really family-friendly, family-oriented employer. Come to us, we'll look after you. They've got great policies, but the reality seems to be a long way away from that, which I don't understand, because there's a great cost in losing lawyers and then needing to rehire people, bring new people in and get them up to speed.
Just a point of information.
Yes.
For Ontario, there has been a program of setting up sort of parallel to the medical professions, locum lawyers to come in and fill in. And I'm not too sure whether it's just under discussion because it's not working as well as they thought it might, or whether it's been canceled already. But it doesn't seem to be a solution, even when they get a bit proactive. So.
Right. I think my sense is there's just a lot of cultural resistance in law firms. Very sort of conservative ideas that people need to be available 24 hours a day, 7 days a week, which is ludicrous.
Right.
There you go. Yes, I'll get to you, Kevin, but I'm going with the students. Oh, all right.
Well, I guess I wanted to invite you to maybe speculate a little bit about the role of breadwinner norms, which seems to be evident below the surface of Australian labor law, but regulating the behavior of men in particular in Australian workplaces. I asked, based partly on some of the research that I've looked at that shows that even where benefits are more generous, and even where And then my own experience as a public service executive, I had more job security by that time than my friend did. And so I took parental leave. I took 7 months. And we had a generous package. But my more senior colleagues, some of them approached me and said, wow, I can't believe you're doing this. And a couple of them said, well, maybe if I had that opportunity, it would have been nice. But it was clearly a culture shift or a paradigm shift. So I just wonder what's going on in Australia. What's the discourse around it?
Thanks, Kevin. I think you've hit the major point here is about job security, isn't it? And I guess as a contextual matter, job security in Australia generally is dropping, so people are concerned. I mean, men aren't taking a lot of leave, and I've also heard anecdotally a lot of discussion of it's better to take annual leave or long service leave than try to take parental leave. That's considered to be less difficult for your job security. So I think it's very difficult, isn't it? In a way, there are times I think I can get a bit depressed about all this and think perhaps we actually have the laws that people want, in the sense that I would encourage people just to start taking leave. Sometimes you just have to do it. And perhaps this is not a fair comment, but there is quite a lot of evidence that in lesbian relationships people are doing things much more evenly. So at least, some people are making the difficult choices. And so I kind of say I think men just have to kind of take what's available to them. There's not a lot available for men, but potentially up to 2 years of unpaid parental leave. And I know financial pressures make that very difficult. And then there's the government's 18 weeks of the minimum wage. But I do think people just have to start making the choices that are better for them, and then at the same time putting pressure on Parliament. I mean, there's not a lot of discussion about improving these provisions. There is a bill that was introduced into Parliament the day I left Australia that was talking about, the bill, if enacted, will increase the 18 weeks to 20 weeks. But the downside is if you get something, paid parental leave under your collective agreement that's more than that, you won't get the government scheme. You'll only get the government scheme if you get something in a collective agreement that's less than the 20 weeks. So there's a moving backwards in a way, I think. So at the moment, some people, fortunate people, have something in a collective agreement which they can take paid leave, and then they might take the 18 weeks at the minimum wage. But that's only about half the workforce, at least, of women have that. Men have a lot less than that. But the thing about collective agreements is that I think that reveals quite a lot about the gender dimension. Collective agreements for women, parental leave, is much more generous than for men. And so they've been negotiated and agreed to. And I can understand that men would say, well, I'd rather have a higher rate of pay than parental leave. But in a way, that's a choice that's being made, I think. So I think people should take what they can, and then keep pressure on the government. Not sure if that answers your question. Were there? Yes. Yeah, the rate of unionisation in Australia used to be quite high. It's running at about 20% or 19%, which is still quite strong, isn't it, relative to many countries. I mean, in the past, of course, unions were quite severely criticised, and I think rightly so, for really not supporting women in the workforce. They were concerned to protect breadwinner jobs from competition with women. But I think it's fair to say these days this is a major issue for unions. There's very little scope, though, for improving standards in Australia now. It's really only through Parliament that standards are going to be improved. There used to be a test case mechanism through what we used to call the award system, which was an important part of our minimum standards, but that no longer exists. So unions are involved to that degree, and they're often involved in collective agreement making, although they may not be if they're not present in the workplace. And then they can also, of course, be involved in supporting claimants, and they do that, particularly if there's an issue about freedom of association. Unions will get involved probably more, I think it's probably fair to say that. They're more heavily involved in that rather than pursuing maternity rights and parental leave rights. But they're there. Yeah.
I don't know if this is fair to ask you, but to the extent that there needs to be a shift in the paradigm, are you suggesting that that shift has already happened in Australian culture and it needs to be reflected in legislation, or are you saying that it still exists in legislation and still exists in Australia and which needs to shift away from that?
No, I think that's a really good point, because I'm not really sure what I'm saying. I think what I'm saying is I think the shift is happening in Australian culture. At least I think for LGBT workers. I guess I'm less confident about the shift between for men to take on more caring roles when they're in relationships with women. I think a lot of men say they want to. I don't know whether they don't tend to. They're not tending to. Now that might reflect just that the legal entitlements aren't great for men. But I think I am saying that I think that the legal system is still reflecting those values. So it's sort of, I think they are interrelated, aren't they? But that's good. Yeah. Yes.
I haven't written your question before, but in your paper you wrote that provided that a father fulfills the eligibility rules under the FLSQ, which he is more likely to
Yes.
than a mother.
Yes.
I was super curious.
Why is that? Oh, well, that's an attempt to reference back to the idea that in the eligibility requirements require somebody to be full-time and ongoing. So not full-time, but ongoing, continuous employment for at least 12 months. Yeah, and women are less likely to have that because we know women are more likely to be in casual, short-term work. Yeah, that's it. Yes.
I'm not sure if your research throughout your academia has been at all comparative, but would you say that there's a country that kind of has as close to a gold standard in terms of workplace for the women? And if so, why is that?
That's a really good question, and I haven't done a lot of comparative work, but you know, Scandinavian countries are often held up as being very good. And I think that there's much more generous kind of leave arrangements for men. The difficulty is that the 18 weeks that we have in Australia is at the federal minimum wage. And I'm sure, like Canada, Australia, you know, many households are run very tightly in terms of their rent or their mortgage, that they really can't afford to have somebody on that, particularly if men are still in Australia paid more. So that's the other contextual issue I haven't mentioned. In Australia, there is still a gender pay gap. Men, on the whole, are still paid more than women. So, I mean, in a way, of course, it makes financial sense. If somebody has to take some time out of the workforce at the federal minimum wage, it makes financial sense that that's the woman, usually. And so that in itself is a problem, isn't it? Yeah.
If you want to know a country that, like, so I'm from Sweden,
Oh.
and we have 90 days of the parental leave is mandatory for the man, and we last 2 years ago when we had an election, like the really big question was whether or not to make it 50-50 for men and women, so that the women can't take the full time, and now it's only 90 days, and the various parties discussing that, but I think, and it's going towards more men taking parental leave, and it's become more socially acceptable. However, still in law firms, and what I've heard and what I've seen from the lectures I've been to back home is that the women are more likely to be, you know, oh, of course you want to take time off with your child, whereas for the men it's like, really, should you? So in practical life versus what the government would go out to other countries and be like, hey, look at us, we have come so far, but you know, not really. But yeah.
Thank you for that.
So I have the impression that to some extent it seems like maybe what's offered by the law doesn't actually meet what people need in real life. And I was wondering if there's, in Australia, to what extent employers and employees in their own negotiations, and you mentioned unions a bit, but in their own negotiations meet those needs in ways the law doesn't. So for example, in Canada, some of the employers that are well known, and I think the federal government is that something you see in Australia where people just meet that date?
I think that's right. So there is some research around that right to request that is a legal mechanism. However, it does seem that employers are giving requests outside that framework. That those requests might not be couched in the language of that framework. And I think that's market forces, isn't it? So in a way, I think that indicates that the law is dragging behind in that sense, that employers are responding because they want to keep that employee, basically. Yeah, but then of course that doesn't help people, does it, where their employer is not prepared to engage in any discussion at all. And so I think that's the issue. If you're in a secure position and you're in demand, your skills are in demand in the marketplace, then you do have a strong chance of negotiating. But if you're a casual, short-term arrangement, then I think that's where it's a problem. If you don't have a skill set that's in demand. Yeah. So it is interesting, isn't it? So it's also, there's a case study there about the way actual practices are moving well ahead and laws lagging behind. Thank you.
So I think we'll have to stop now because I think there are people from another class kind of starting to circle outside. But I would like to thank everyone for their questions and for the really good discussion on top of a really informative and I think illuminating paper. So thank you so much.
It's my pleasure. Thank you.